power per SC, it can never amount, by implication, to an enlargement at any power expressly given. It can never be the legitimate source of any implied power, when otherwise withdrawn from the Constitution. Its true office is to expound the nature a. DCX-TCNT an application of the powers actually conferred HV the Constitution, and not substantively to create them, 7-10, 713 in re. The Berubari Union and Erkanj of Enclaves, 1963 SCR 250, and Attorney General VHRH. Prine Ernest, 1957 AC 4036 referred to. Right to FJ property did not pertain to basic structure or framework of the Constitution, although the preamble gives a prominent place to securing the objective of socio, economic and political justice to the citizens. There is nothing in it which gives primacy to claims of individual right to property over the claims of social, economic, and political justice. There is no clause or indication in the preamble which stands in the way of abridgment of right to property for acquiring socio-economic and political justice. Indeed, the dignity of the individual upon which also the preamble has laid stress can only be assured by hearing the objective of social, economic, and political justice. The directive principles embody a commitment which was imposed by the Constitution maker on the state to bring about economic and social regeneration of the Titiminj, millions who are steeped in poverty, ignorance, and social backwardness. One, they incorporate a pledge to the coming generations of what the state would try to usher in. The stress in the impugned amendments to the Constitution upon changing the economic structure by narrowing the gap between the rich and the poor is not a recent phenomenon. This has been the objective of the national leaders since before the dawn of independence and was one of the underlying reasons for the First and Fourth Amendments of the Constitution. The approach adopted was that there should be no reluctance to abridge or articulate the fundamental right to property if it were felt necessary to do so. Supreme Coup. T. Reports, 1973 Supasir, or changing the economic structure, and to attain the objectives contained in the directive principles. So far, the QBU CJ Tyan is concerned you to whether the right to property can be said to pertain to BA1IC, El Rupture, or framework of the Constitution. The answer should plainly be in the Neptev Basic 11 RUC. UFE or framework indicates the broad outlines of the Constitution, while the reab to property is a matter of detail. Sipulpo 716 to 720. Parliament can by amendment of il convolution in lar rangs il deg power. There is nothing in the Constitution which prohibill or in another way prevents the enlargement of powers of Parliament as a result of constitutional amendment, and such an amendment cannot be held to be impermissible or beyond the purview of Article 3 on 68. Article 368 ITCLF gives inter gia the power to amend Article 368, and an amendment of Arley CLC 368, which has been brought about in the manner prescribed by that article, would not suffer from any constitutional or legal infirmity. 721 to 723. Ermish Ryan Burries. Michel Lennon, 1935 Irish Reports 170 referred to the Constitution 24th Amendment Act 111111 Uldin a Cortanu with the proege laid down in Artic 368 of Ile. CA 101 TY1 Yushin 1 at 11. It existed before the passing of the said Act, the AC do 1 nor suffer from any infirmity, and 111 such is valid. OPM 737 759. The amendmental in Article 31(2) and the addition of D, 2B of the Constitution. 25th Amendment Act are permissive under TLM Almer Z 368 and are therefore valid. Key 739, 741, 759. The amendment made in Article 31(2) by substituting the word amount for the word compensation is necessarily intended to get over the difficulty caused by the use of the word compensation. Whatever may be the connotation of the word amount, it would not affect the validity of the amendment made in Article 31(2). There is no infirmity in the changes made in Article 31(2) Servicium 39, Bella Banerjee, 1954, SCR, 58, Vlirabelu Mudaliar, 1965, L. SCR 614, Shannon L. Mangadas, 1969, 3 SCR 341, and R.C. Cooper, 1973 SCR 530, referred to by the addition of CLE2B. The amendment seeks to overcome the effect of the decision of this court in R.C. Cooper v. Union of India, 197013 SCR 530 that Article 19.1, Vernon 31.2, Arc not mutually exclusive. The change made by the addition of Clause 2b in Article 31.2 is permissible UNDCR Article 368 and cannot be held to be invalid. P. 741. The first part of Article 31C introduced by Constitution 25th Amendment I1 valid P. 759. The first part of Article 31C is similar to Article 31A except in respect of the subject matter. Both Articles 31A and